November 2004, there was a tragedy unfolded in Kulai, Johor, as a father stood accused of murdering his 3 children. Then, 16 witnesses were called. Their voices, alongside the law, would decide his fate. The children's mother, Halima, then spoke of her troubled marriage. And she said that after they got married, she was not happy at all. The accused hit her. Then she fled away to a welfare home, leaving the children behind. The neighbor, Jamal, was the first to discover the horror. At 3:30 in the evening, on the 20th November 2004, the neighbor, Jamal, heard cries for help. Then he rushed inside the house. When he reached inside, he found that the accused and his daughter, Malur, were hanging. Then he rescued them, cut the rope from the accused, and revived him. And the situation of the children, they were already lifeless.
Help! Help! Help!
He admitted attempting suicide. He was depressed but not insane. Depression could lead to suicidal tendencies, but he knew the consequences of his acts. He may have believed that by killing his children was the right thing to do, yet he was not psychotic.
When I examined the bodies, all 3 children died of asphyxia. Signs included blood clots, lung congestions, petechia on the face, and blue fingertips. The deaths occurred within 24 hours before the postmortem at 10:30 am on 21 November 2004.
At the close of the prosecution case, the court found a prima facie case. Then the accused was ordered to enter his defense.
In his defense, the accused claimed that he loved his children. At 9 in the morning, he found them dead. He then proceeded to hang himself in the adjoining room on the upper floor. He also said that the children were asleep when he got home at 2 am on 20th November 2004. He hung his security guard uniform in the other room, not in the same room as the children. When he woke up on 20th November 2004, he went straight away to the room of children and he found that his 3 children are dead. That was his defense. He said that his daughter MLJU confessed that she killed them with raffia string because of Halimah. The accused decided to die. He kissed his children's feet, then tried to hang himself.
The public prosecutor stated that they don't simply charge him with murder without evidence and witnesses. Although the case depended entirely on circumstantial evidence, the evidence in totality pointed to the fact that the accused was guilty as charged. Because the only person or persons who could have strangled the deceased was the accused or his daughter, MLJU. However, the accused was the only adult in the scene, and as the adult, he would have had control the situation in the house. MLJU, as a child of 14 years old, would not have the mental capacity or physical strength to have committed the murders. Further, as a reasonable father, the accused would have been expected to vent his fury on MLJU after discovering that she had murdered the 3 deceased. But the absence of injury on MLJU attested to the fact that she was not physically chastised by the accused. Instead, the accused calmly proceeded to commit suicide, which was wholly inconsistent with the conduct of an aggrieved father. There is also some witnesses that give statements that very contradict with the accused's defense. So, at the end of the case, there was no doubt. The accused was guilty of murder. Then the sentence is to be hung by the neck until death.
Have you ever wondered how was the accused charged with murder in this case? For criminal cases, in order for a prosecutor to charge someone in committing a crime, there are 4 elements that need to be fulfilled. Those elements are actus reus, criminal act, mens rea, criminal intention, concurrence, and causation. In this case, Hassan was charged with 3 counts of murder under Section 302 of the Penal Code. A postmortem of the 3 victims, who were his 3 children aged 6, 5 and 3, revealed that the deceased was strangled to death. For a better understanding, let's discover this case by using the IRAC method. Issue. The issue is whether the accused caused the death of his 3 children with intention by strangling them, thereby committing murder under Section 302 of the Penal Code. A rule. According to Section 300 of the Penal Code, if the act of causing death has been done with intention, whether it is intention to cause death or intention to cause bodily harm, either way are defined as murder. To charge someone with Section 302 of the Penal Code, the public prosecutor must fulfill two elements according to the Section 300 of the Penal Code. Those two elements are actus reus and mens rea. Actus reus means the action of causing death, while mens rea means the intention to cause death or bodily harm. Thus, the public prosecutor fulfill those two elements, the accused will be charged under Section 302 of the Penal Code, which is death penalty. Application. In this case, medical evidence showed that the children died because of asphyxia, which is caused by a string, an act sufficient to cause death. The accused was the only adult present at the material time, and it was unlikely that Melo, a minor, could have killed all three children. Moreover, the circumstantial evidence pointed exclusively to the accused, and his suicide attempt supported a murder-suicide inference. This fulfilled the actus reus elements whereby the three deceased died because of strangulation. Other than that, the strangulation itself actually has directly showed that the accused has the intention to cause the death. In fact, the etching on the door clearly showed that the accused knew the death will happen. The psychiatrist's evidence also confirmed that the accused was not unsound of mind and understood the nature and consequences of his actions. Therefore, the element of mens rea also has been fulfilled. Conclusion. Based on all the circumstantial evidence, both the actus reus and mens rea for the murder were fully established. Therefore, it was sufficient enough for the public prosecutor in proving beyond reasonable doubt that the accused was the one who strangled his three children intentionally as required under Section 300 of the Penal Code, and the accused was convicted of murder and sentenced to death under Section 302 of the Penal Code.